Did you know that a 2023 tort reform has resulted in significant reductions for defendants in auto case accidents? Well, here to explain more in depth about these changes, we are happy to welcome back Katherine Stone from Injury Florida Law. Katherine, welcome back. I mean, so many changes. We're definitely seeing them now. You've seen them on the daily. Let's dive into this first one, though. I know you want to talk about, something that's really affecting a lot of people and maybe at the end result of the case.
Right. So, this is kind of a continuation of, there were a lot of changes in 2023 that really significantly impact the injured party in an auto accident claim, a slip and fall claim, any kind of claim that involves negligence. And so basically one of those ways was prior to filing suit, you would normally present the insurance company with a demand package. That demand package includes, the history of the case, how the accident took place. If there's an accident report, that gets included. If there's photographs, that gets included. Medical records and medical bills get included. And prior to the change, they had 30 days to respond to that demand package. Typically, that demand package needed to be sent prior to filing a civil complaint. Depending on the policy limits as to whatever the case was, they had an obligation to tender policy limits or negotiate in good faith within that time frame. They changed that to extend it from 30 days to now 90 days. So as a practitioner, you've got to make sure, now that statute of limitations is 2 years, you've got to make sure that you get all of your documents, everything you need well in advance of that 2-year mark. Make sure you have 3 months now of your demand package submitted and allow them to review it for that 90 days. So it's really forced everybody to really act proactively versus where we were prior to 2023.
Where you had time, I don't want to say time on your side, but you had longer to work with your clients.
You had much longer. So now within those 90 days, if they still continue to, they still have an obligation to act in good faith, but if they refuse to do so, then they're not obligated to pay bad faith attorney's fees. So in other words, if they refuse to negotiate in good faith, or they don't tender the policy limits in something that they clearly should have, it took away the ability to be able to get additional attorney's fees and costs, which was essentially a penalty against them. And so everything has kind of transpired to remove that additional penalty from them.
So what do you tell your clients? I mean, I feel like there's been so many things with the time frames, and now this too, that directly affects them.
Definitely within my own office, we have to communicate with the clients more often. We have to know what's going on with them more often. We have to educate them on, you have to be more proactive in making sure that you can't let lapses in medical treatment happen if you're still needing the treatment and still going to the doctor. Everything has to move a lot quicker. Like our calendars now just have to move a lot quicker, and we have to stay on top of things to make sure that we don't miss any deadlines.
And again, we've only got a few seconds left, but it just seems too that 30 days to 90 days gap. I feel like, people who are filing that have to be a little more prepared.
Well, and now, you're not going to get a response to your demand as quick as you may have.
Yes, which of course affects the bigger picture down the road.
Which prolongs the injured worker getting potentially financial recovery.
This is why we are glad Katherine Stone is here, a part of our team, InjuryFloridaLawFirm.com. If you've got questions, she can help you out. She can guide you. And again, we're so happy to have these conversations on our show here.